Hey y'all, what you're looking at now and joining us live with Yantha Rico trial, major hearing.
Hi, good morning, council's interested parties. We are back on the record in the matter of the state of Georgia versus Cleef Adams et al. In 22 SC 183572. Let's see, Mr. Stillwell, Mr. Sharp, good morning. All right, Mr. Williams, Mr. Steele, Mr. Adamson. Okay, good morning. All right, Mr. Kendrick and Mr. Weinstein, good morning. All right, Mr. Ewing, Mr. Matthews, Senior, good morning. All right, Mr. Nichols, Ms. Westmoreland, and tis you. Okay, all right. Good morning, madam. And Mr. Ryan and Misty Williams, good morning. All right. Mr. Helsky, Mr. Atkins, and Ms. Love, good morning. Since that ruling, there has been a case by the name of Baker, and it is case number S23 Alpha 0860, decided 5 March of 2024, concerning um, issues that may bear upon the court's ruling. Mr. Steele and who's ever arguing for the state, I'm willing to give you 30 minutes apiece because I've read Baker, and of course I've already made a ruling, so it doesn't really require me to get spun up or educated that much on it. So, consistent with that, I'll start out, Mr. Steele, since it's your motion. Go right ahead. You may. Now it is. Thank you.
Okay, Your Honor, thank you so much and good morning. Honorable Court, good morning to everyone. I did file what the court has already announced, and I appreciate the court's time to consider the Baker case. In the Baker case, Your Honor, I know you've read it, heard what you just said. I focus then on the fact that Baker was not a gang case, not a Rico case, not a conspiracy case. A Rico conspiracy case, I understand that, but it did involve the playing of just a video, what was deemed by the Supreme Court of Georgia, a rap video, no lyrics, because the lyrics were not understandable. But the reason that I found it important to raise, on behalf of Mr. Williams, our supplement to the motion, and let me number 2 motion to strike, filed on the 6th day of March 2024, the day after Baker was decided, was that the highest court, and it's a 7-2 opinion in Baker, really took to task the use of a video, just the images. The video was, and I'm quoting from Baker, the video was glorifying violence and gun violence and a sort of street life, glamorizing it. And then I go to footnote 16, and I've given the Honorable District Attorney already a copy, and I've given this Honorable Court and the Honorable Mr. Kearns a copy of the 3 cases that are in footnote 16, where the Supreme Court of Georgia wrote, we note that the probative value of the rap music video was further diminished by the state's failure to present any evidence that Baker's performance of Crawford's rap song was not wholly theatric. And then they cite the United States versus Gamory, Gamory, which I'll get to, Your Honor, and they write, explaining that a rap music, they being the Supreme Court of Georgia, explaining that a rap video was minimally probative under Federal Rule 403 because there was no proof that the appellant authored the lyrics or that the views and values reflected in the video were in fact adopted or shared by the appellant. So I thought that was important because here the state is trying to introduce numerous lyrics and videos.
Let's talk about that. Baker arguably involves the introduction of a video which there's little nexus to what they're trying to prove. Could you discuss for me how that, in this particular case, the state has said, look, we're gonna tie this to some aspect of membership, of leadership, and other things that are required to be proven under the gang statute. So tell me how, and if you could distinguish that for me or talk about that, because I think the facts in Baker are a little bit different than the facts in this particular case. And remember, I've also told you it's subject to foundation. So, so address that for me if you wouldn't mind.
Sure. So I don't believe that the state will show any type of nexus, and in New Jersey versus Skinner, Skinner, which is 95A as in Atlantic 3D 236 2014, cited, the reason I'm using it is cited in that footnote 16, and in the copy of the copy that I gave this Honorable Court, the printed copy this morning, and the parties in page 11 of 15.
Are you talking about Skinner?
Yes, it should be on top, Your Honor. New Jersey versus Skinner. And on page 11 of 15, it's footnote 5, which is at the bottom right. And I think that answers for me the question, and that was cited by our highest court in Baker. And it specifically says in that footnote, of course, rap lyric evidence that provides direct proof against a defendant, such as an admission or details that are not generally known and dovetail with the facts of the case, should be analyzed for relevance under 401 and evaluated under 403 standard for prejudice, and not the standard for prejudice under a Cofield analysis. And then they cite another case from New Jersey, recognizing intrinsic nature of evidence that directly proves charged offenses as excluded from 404B's analytic framework. A jury need not be shielded from a defendant's confession simply because it conveyed in a rap or other artistic setting. And what I'm saying here is, Your Honor, the state can't do that. When we had that last hearing, it went till late at night, the state was saying things like, and I'm just using out of the indictment, I ain't killed nobody, but I had something to do with that body. They just said, there it is, Judge. That's what we're saying. We're saying that Mr. Williams' hands are always clean and he has other people kill for him because he's the leader. That lyric, first of all, is used in other songs, which I've mentioned to court previously. But in addition to that, that's not something that's unknown. There's no details. There's no nexus. This honorable court, to admit that, is just admitting the artistic work, doesn't know if it points to any type of killing. It just goes to propensity. And I believe under Baker, 403 analysis should shield it. So I hope that answers your question, but that's what Skinner says to me from New Jersey. That was cited by our highest court. In Commonwealth of Massachusetts versus Gray, which is another case I've given this honorable court and the parties. And it's on page 12. Oh, I'm sorry. It's 978 New England or New Northeast 2D NE 2D 543 2012. On the opinion that I've given to this honorable court and the parties on page 12.
Up 13?
Yeah.
Okay.
On the left-hand side, the first full paragraph, it's in the center of 12. The video, I'm just reading what the court wrote from New Jersey. The video was produced at an unknown point in or before 2005 and was available on a commercial website promoting rap artists. The defendant did not write or perform the lyrics or produce the video, and it was not found in his possession. The lyrics show no connection to the defendant that would suggest that they were, biographical, or otherwise indicative of his own motive or intent at the time of the shooting. Yet the video was admitted specifically as an asserted statement of gang allegiance by the defendant based on Sheehan's, which is Sheehan, possibly as voir dire testimony to its meaning. Even if the video had contained direct statements of the defendant's gang allegiance, we are not persuaded by the opinions of courts in other jurisdictions that view rap music lyrics not as art, but as ordinary speech, and have allowed their admission in evidence as literal statements of fact or intent without contextual information vital to a complete understanding of the evidence. And to answer your question, I hope I'm answering, but the state can't do that. They didn't proffer to you anything that would associate these lyrics with a certain crime. The closest they came is they told the court that trestle tree, that Jeffrey Williams said the word trestle tree, which is a section, a street where crimes were committed in this case. The fact that he is using trestle tree in a song certainly cannot be that he's somehow involved in that crime. In addition to that, the prosecution has spent 4 months showing or trying to show that Mr. Williams is the leader of this gang. They have put on over objection Mr. Bean's recorded statement with Detective Quinn saying that Jeffrey Williams he commands Mr. Murphy to do something. They put on Trontavious Stevens, who said inconsistently, but said Jeffrey Williams is a member of the gang. They put on that Jeffrey Williams is the slime, the big slime, King Slime, rather, excuse me. They put on Detective Belknap. They are going to use, over objection, Detective Gaither as a gang expert on YSL. They're going to use Detective Dennis as a gang expert on YSL. Over objection, they're going to use Investigator Viverito as a gang expert on YSL. And all of them make, for certain, over objection, Mr. Williams the head of this supposed criminal organization. So why did the lyrics have any probative value if it's simply cumulative? I'm trying to answer your question, but my point is to use the art, to assume that is statements that the state argued are confessions. That's what they said. These are confessions. They said that we didn't go out and find them. Mr. Williams, handed them to us. These are his inner workings of his mind. But it's an artistic industry that our courts now, for the first time, this is the first time in Georgia, our court has said in footnote 16, we got to be careful. And they cite to these cases that say you got to be careful. The next case cited by our highest court is United States versus Gamory, Gamory, and that's 635 F3rd 480. It's 11th Circuit 2011. Again, it's in footnote 16 of the Baker case. And on the copy of the opinion I give in this honorable court and the parties, it's in Division B, as in Barry or Bravo. And that starts on page 7 of 11, Your Honor. And it's entitled The Rap Video. These are lyrics and video, just like the Gray case and just like the Skinner case, where the lyrics and video. And I am targeting on page 7, the right-hand side in the center paragraph that starts with the following. Based upon our independent review, I'm sorry. Yeah, no problem.
All right. There go Bud. There go my boy.
Right answer. In United States versus Gamory, and it's on page 7 of 11, Your Honor, on the right-hand side under the rap video. Starting in the center, the 11th Circuit wrote, based upon our independent review of the rap video and the totality of the record, we conclude that it was error under 403, Federal Rule of Evidence 403, to play this rap video to the jury. We recognize that the video could be construed to discuss Gamory in as much as the lyrics were
Similar, probably, argument. So, I said you got some similar argument. That's what I was.
I heard you say I can make it now.
Yeah.
Okay.
Yeah.
Would you like me to make it now?
Yes.
Okay. So, Your Honor, just for clarification, I filed motions regarding two different pieces of
Yeah, you have a motion.
One is a song.
Yeah, one is similar to what Mr. Steele filed in terms of Baker, and then the other one was a motion in limine to strike regarding song lyrics.
Right. I mean, both Baker touches upon both.
Okay.
In Your Honor, what I'd like to do is, just so we're all clear, these last less than a minute, if I could just publish them to Your Honor so we can see exactly what we're talking about. Mr. Weinstein, if you'd help me out. Either one is fine first. Yes, sound.
unmuted. Hey, Mr. Kokomo. If you don't know what it's
Gotta cut your sound off.
They were so young. Y'all should have did that Rico back then. 16 and 17, 18 of these little boys.
I'm trying to rob him.
This is a video shoot that they was doing, y'all. And we couldn't play it because of the music. They was so young. Why they ain't do the Rico then? They old now.
Yes.
Okay.
And then this is a social media post that was provided in Discovery.
All right.
Yes.
And this is the second one?
Yes.
The same shit that got Big and Tupac killed, little fuck, nigga. Pussy ass nigga, you talk bitch ass killed. Yeah. Hey, gang, You bring your pussy out here, you gonna see me. I'm at your fucking neck.
Fuck anybody.
Why would you play that?
So that's still well too.
I don't think that was the entirety.
I'll just play it again.
Thought about it when I hear all that cussing.
That same shit that got Biggie and Tupac killed, little fuck, nigga. Pussy ass, nigga, get your bitch ass killed.
For life.
Yeah,
Hey, call that loud.
Hey, gang, you bring your pussy out here, you gonna see me. I'm at your fucking.
All right,
So that's still well too.
that is still well too.
Okay. All right. What's that called? That's just is that just a
But it has no ties and no nexus to any substantive offenses. Essentially, in that rap video or in that verse, I believe that you can see my client. Now, I know the state has pointed out in previous pleadings, he is allegedly wearing a YSL necklace, and he's allegedly wearing red. What does he say? He says, he talks about going to, I believe he says the plug, but essentially robbing drug dealers or drug distributors. He boasts of keeping a stick, which common parlance is an assault rifle, on him. And he says, I just beat a murder rap, paid my lawyer $30 for that. Now, none of those statements, robbing drug distributors, that has no direct nexus to any substantive charges in this case. Keeping a stick has no direct reference to any charges in this case. I just beat a murder rap, paid my lawyer $30 for that. Now, I think it's fair to say that that is most likely a reference to being wrongfully arrested back in 2015 for the murder of Donovan Thomas. He was arrested in October of 2015. He stayed in jail for a long time as his co-defendants' cases had their preliminary hearings, were dismissed. Eventually, the state dismissed cases against all three other individuals that were charged in that case, along with Mr. Stillwell. Mr. Stillwell was granted bond. And as artists do in their expression in hip hop, it may have been a certain level of fictionalization, because we know, in fact, it was not dismissed. He was, in fact, on bond. It was no cap, was the artist, Mr. Kobe.
proof that the appellant authored the lyrics or the views and values reflected in the video were in fact adopted or shared by the appellant?
Well, Gamery deals with a different set of facts, but just because my facts don't match Gamery doesn't mean the opposite conclusion.
No, but it shows the probative value is stronger in involving your particular accused.
Okay.
And we may disagree with that. I'll have to see hear what the state says about it, but
fundamentally,
and that's subject also to foundation, but we'll see.
Fundamentally, Your Honor, I just don't, probative value, there has to be probative value towards a facted issue.
Yeah, whether or not your client committed a murder.
But he doesn't admit to committing a murder. He talks about being arrested. And that is not an issue. He has been arrested. Nowhere does he say, I committed a murder on that video. If he said that, we'd be in a much different position. And he doesn't say that. And that's the whole point, is all he's saying is I was arrested.
Well, it also depends upon what else the state has to proffer in regards to that. And I don't know what they have. So, I mean...
Okay, well...
So I mean, you know, like I said, so like a lot of these lyrics and songs are subject. That's why under the...
Regarding...
Under 103, and now I let them in preliminarily subject to foundation. So, and I'm still going to do that with your client and anybody else who may be featured in songs or videos. So,
regarding the staying on the video, okay, and then I'd like to address the other the other video, the social media post as well. But staying on the video, if we if we were to agree that there's relevance of red YSL necklace and saying he was arrested, that is probative of something, then you have to get to the balancing. And it's prosecutorial need, overall similarity between the acts, and temporal remoteness.
I'm just gonna give you a heads up. You got about 10 minutes left, okay?
Okay. Well, so, Your Honor, regarding probative value.
Robbing the drug dealers and carrying a sick part of the homicide, the alleged homicide?
No. No.
Okay.
And,
Right.
And so, danger of unfair prejudice, I think Mr. Steele talked about it. Obviously, references to robbery, and I think that's pretty self-explanatory. And essentially what it comes down to, the real value of this is not to show that there's a nexus, an evidentiary nexus to any of the offenses that Mr. Steele was charging, but the real value is it comes down to propensity, shows a violent disposition. And you know, there's several cases. I know I want to preserve some time. Strong v. State, 309 Georgia 295. We would ask that Your Honor rule both videos inadmissible in this trial. Thank you.
All right, thank you, sir. All right. Argue for the state. All right.
All right, I got a half hour.
I've already started the timer, sir.
So the broader realization I'm having as I'm hearing these defense arguments, Your Honor, is that this Baker case came out, and it's a case that applies 403, but it doesn't change the law on 403. I think we're getting arguments that sound similar to the idea that, you know, Baker came out and there's this case where a rap video was excluded, so therefore that's now a change in the law that means all rap type evidence is now radioactive under 403. That's a flawed proposition, as I'm going to get into. So I'm going to start with Mr. Williams' arguments, and then I'm going to try to get into Mr. Stillwell's arguments in a little bit more specific. And I may refer to my colleagues when it comes to the granularity, but I just wanted to provide an outline of our thoughts on the law here. So Baker is being touted as though it kind of automatically operates to vacate this court's lyrics order from November. That's not the case. It doesn't suggest that. It certainly doesn't compel that. I want to start with the fact that Baker is a 403 case. And as such, it's a limited fact-specific holding. We know that the court and all the parties have read Baker, but just to reiterate, the sole enumeration of error in Baker was the trial court abused 403 in letting this video in, okay? So there was a pretrial motion in limine to exclude specifically this video, by the way, a particularized pretrial motion. And then the trial's murder that happens in one night, and the split-second decision that somebody may or may not have made about a bullet that went through a security guard. And then it's like, well, what kind of person would do that, you know? And it's like, well, how about this kind of person? The kind of person in this video. And it changed the whole dynamic of the case. This is in stark contrast to what we have here when it comes to the lyric evidence in this case, which this court has already correctly ruled on.
How would you address Mr. Shart's issue of, okay, you got about robbing drug dealers, carrying a stick, and the I beat a murder rap, paid my lawyer 30, etc.
Nature and existence of the organization.
Okay.
So moving forward, I wanted to address something that came up.
Well, what about the last? What about the last? His last statement, beating the murder rap.
Well, it's a question for the jury. I mean, on one hand, you can say I beat a murder rap, which means I was falsely accused of murder and I was vindicated in court and I had nothing to do with it. And the jury's free to believe that. But then when you couple it with how much you paid your lawyer, you're bragging about money, and then you're bragging above and beyond that. You're not saying me and my clients follow the law. Me and my clients are within the law. You're saying me and my clients are above the law, which goes to the mindset and intent. And so it all goes to count one and then some. So it's not a propensity, and the court's already ruled that the lyrics evidence is not going to be offered for that. And if that answers your question, I'll jump forward here a little bit. I wanted to go to Old Chief just briefly.
Okay.
To imply, because there was some discussion about 404B and how that plays into the 403 analysis. Again, Baker was a very limited circumstance where it was no other argument to make other than this had to be used to show propensity to encourage the jury to convict. That's what happened there. But that's not that's not any new type of application of the 403 rule. Again, Baker doesn't change the law on 404B, doesn't change the law on intrinsic, and doesn't change the law on 403 in general. The idea that, 403 encompasses evidence that may lure the fact finder into declaring guilt on an improper basis. Even in Old Chief back in 97, they said that such improper bases are to include bad character and propensity. So it's been the law for, some 20 years plus, at least, that propensity analysis does occur within a 403 analysis, and that's nothing new. Again, that goes to my point, which is Baker doesn't change the law on 403. It's been that way before, and it's been that way after. So the court already correctly applied that law in its lyrics order, and for that reason, we want the motion to be denied. And then the very last point I'll make with respect to Williams is that he's apparently trying to resurrect these arguments that failed before about how, because we don't know the provenance of these lyrics or these statements, or the meaning can be arguable, that's some sort of grounds for excluding them. But even in Baker and the footnote that the defense is making hay about, footnote 16, even in footnote 16, it literally says that, or acknowledges that those considerations go to probative value, not admissibility. They're talking about marginal probative utility and how, the failure of the state at trial to show that these people actually said this stuff versus it being kind of put on them. That goes to weight, but weight is a jury question. The jury resolves the weight, they can decide whether they think this means something or other, or whether they think, the fact that Stillwell's up there on the video saying the exact statement, are we supposed to attribute it to him, or do we attribute it to someone else for some reason? The jury is fully able and authorized to make those conclusions. So that's going to be my main sort of, one other thing. Baker, the fact that it's so wildly different from this case actually supports the state's position here, if you think about it, because there are so many differences as I outlined. And again, it's an extraordinary remedy that was applied in an extraordinary case. It was called for in Baker. It's not called for here. Just to reiterate, the very fact that the defense's opening statements, their cross-examination, and throughout this case have been categorically to deny that YSL is any kind of criminal enterprise, any kind of criminal street gang, any kind of anything other than a rap label.
They are really paying attention. I like that.
And the probativity of these pieces of lyrics evidence. And for those reasons, we think that the motion should be denied. Now, when it comes to Mr. Sharp's arguments, those were more recently filed, so I don't have as developed of a take on them. And I may refer to co-counsel for some of these details. But the Smile It Off video, let's call that what? Was that Stillwell 1?
Yes.
I think we kind of already covered that with the, hey, my Lord 30, to beat the murder rap, me and my slides above the law. I mean, that's him talking. There's no question about him being the person that said that. And more than that, you look at
being offered for any other reason other than identity, and are you talking about identity for what reason? Well, involvement in the criminal street gang, or identity in terms of the homicide?
Well, it could be for all those, but
I'm asking you because Mr. Shard has said, it's not really relevant, but he won't kind of concede that. But so tell us, or tell the court why it is it, or address those three issues. One of them is he's robbing drug dealers, okay? And he carries a stick. The last thing is I beat a murder rap for 30. I beat a murder rap, paid my lawyer 30, and then me and my slimes are above the law.
Well, that's overt Act 95, and so if you look at the indictment, overt Act 95 literally says that statement is in furtherance of the conspiracy, and if we can't play a video of him saying those words, how else can the state prove that act?
What about the robbing drug dealers and carrying a stick? Should I exclude that?
No.
Why not?
Well, it provides evidence of the nation existence of the organization.
What?
That's why I asked him. That's why I asked Mr. Shark. Did the homicide occur with a as a result of robbing a drug dealer, or was it allegedly Mr. Stillwell carrying a stick, a assault weapon?
Well, there had to be some sort of weapon for this murder to have occurred. I don't have any specific nexus about why the sort of words before the words that are admissible are specific to this, but we do have an entire overt act built around it, and the things that are said in context, right before, right after, sort of the YSL associations, especially even in the Stillwell 2, where you have YSL for life, and you have blood love all the time. You have all these indicators of this is evidence of the organization.
I get all that, but the specifics of robbing drug dealers and this defendant's reportedly carrying a stick. What relevant? I mean, that could potentially. Though, I want to parse out those three statements.
I'll take
I don't have any. I'm like Mr. Sharp. The court doesn't have any.
Lady, sit down. You know you're behind in front of that camera.
I disagree with him about the murder, about the statement about the murder rap. Okay, but I do think that you're going to need to address the issue of the robbing drug dealers and carrying a stick. Unless you're going to.
And she just got to stand up.
Like I said, lay more foundation in regards to that.
Well, you're gonna have we have allegations that Dirty Red is a drug dealer. We have Donovan Thomas, who was murdered with an assault rifle, and there's indications that it's a rival gang situation. So it's not maybe
the issue with Donovan Thomas hasn't come up yet. At least I don't think so. The evidence hasn't been presented. But Dirty Red was just covered just a little while ago. So flesh that out for me in terms of robbing drug dealers or Dirty Red.
Look at her.
Well, they're talking about the stuff they do. I mean, talking about the way they do it. It's a party admission, Your Honor. These are parties making statements about the things that they do. It's highly probative. I mean, this is not somebody else saying something and it gets slapped on here. And there's, and they're not like in that Gamry case where you have a video where the defendant wasn't even present in the video. You have them. These are party admissions. Like what a defendant says, unless there's some specific statutory rule excluding it, like Miranda or something like that. These are extremely probative statements. And to just say, oh, the jury's going to be inflamed, we have to shield them from these facts, these things, these statements, these words that the defendants uttered for really, I don't know, no reason at all. To me, it just kind of strains credulity. And
I'm just making sure that under Gamry, that GAMORY, that you've got a video there that was minimally probative. I'm just asking you, as a proponent offering this particular evidence, if it's going to go to more, or if what you're going to present will potentially be more probative than it has to be more probative than prejudicial, not minimally probative.
That's correct.
Okay.
And I take the court's point, which is that some of that stuff in Stillwell 1 is maybe more, at this point, obviously probative and direct than some of the other stuff, which may be at this point apparently more diffuse. But again, we have...
That's why I'm telling you at this point in time, I mean, all of it's subject to foundation, but, certainly it's something that I'm watching. I'm watching for the other stuff I've already admitted, but, or at least conditionally. And I think Mr. Shard is just raising this as part of his issue under what's been presented so far and under Baker.
Sure. And then I guess I'll just leave with one other piece of grain of sand here, which is the witness that we're kind of in the middle of, Miss A.B. The state's theory is, of course, that, she was robbed, she was dealing drugs, I mean, I can think of a lot of different things that the lyrics could apply to. There's no, with regard to those particular lyrics.
But back then, that's how they were doing.
Part of the case that applies.
Back then, that's how they was rapping. Rapping back then is different from the rapping what they doing now. They're being more careful what they saying now.
That's what you have to. I mean, that's kind of what Baker and the other cases kind of tell me, is that I just can't admit this for sure.
We should sit down.
Over dramatic, but you have to admit it for
Nice.
tying to some specific or linkage from some particular nexus.
Well,
So
I'm
that's
gonna
why
default back-
I'm telling you that it's got it's that's why it's important.
I'll just default, Your Honor, back without wasting any more time. I'll default to the idea that it's an admission of the party concerning the nature of the enterprise
Okay.
and how things work.
All right.
And with that, I guess, unless there are other questions, I'll conclude the presentation.
No, I'm good. I'm good. All right. Thank you, sir.
Yes, sir.
All right, folks. I'm going to take probably about 10, 15 minutes. I need you to take comfort, and I would encourage y'all to do the same. And then I'll come back and let you know my thoughts, okay?